So documenting other people's observations, sometimes cataloging and documenting any ongoing or continued contact between our client and the accusing party is vitally important. For example, if someone accuses our client of rape for an incident that happens on a Friday night, if they continue to text or make phone calls to our client Saturday morning, Sunday, a following week, or they're having communication through various social media platforms like Snapchat or FaceTime, emailing, things like that, sending messages through other parties. Sometimes law enforcement may not know that those things have transpired because all they're hearing is a complaining witness saying, I was sexually assaulted, I didn't give consent. But if we can show that that person continued to contact our client, it certainly makes it much more questionable about whether or not that person actually believed that they were a victim of a sex crime. And the best sort of layman's explanation of this would be if you're accused of a rape, most people don't reach back out to their rapist to have contact with them, or they won't have breakfast with them in the morning, and they won't go to a party with them, or see them at school, or see them at a practice or some extracurricular activity and act as though everything is normal. Doesn't necessarily mean that a crime did or did not happen, but it certainly is a concerning issue for prosecutors and law enforcement if you've got a complaining witness who claims to be fearful or devastated by an act having occurred, but they continue to engage in contact. If there are communications between the complaining witness and other parties, or our client has had text messages or phone calls from other individuals who have asked him about the offense, and we can show that they've continued to maintain a very consistent denial of these allegations. Many times that is an important thing for us to document and preserve. So, like I said, consent is one of the key defenses that is often available to us. On occasion, the question is who done it, meaning an individual was sexually assaulted. They've accused our client of it, but there's not physical evidence to corroborate that victim's story that our client was the one who's responsible. And so having a high aptitude or experience level with various types of information is something that our law firm has that many other firms simply doesn't have, is that background experience in working with experts, lab technicians, forensic examiners, crime scene technicians, individuals who have expertise in analyzing and reviewing data from computers or other technological sources, DNA experts, toxicology experts. All of those various types of evidence can be hugely relevant if the question is who done it. Meaning if there is a plausible alternative party or another suspect who potentially could have committed the crime, we do our best to try and make sure that we're preserving, documenting, and at least raising that issue as doubt as to our client's culpability. Each case is case specific. Every fact pattern is different. And so there's no hard and fast rule about how we handle an individual's case because every case is a little bit different. The circumstances with which the crime allegedly occurred, some allegations are very delayed in time. In other words, if someone reports a month or a year after the fact that they were sexually assaulted, they may on their face be very credible and believable. But if a lot of things have transpired or there's been a huge lapse in time between the act itself and the time that the report came about, or there was a significant delay in how that investigation took place, those are things that we'll highlight and utilize to our advantage when trying to convince a judge or jury that the crime simply didn't occur. We try to raise as much reasonable doubt as we can because, as I described earlier, many times we can't prove that our client didn't commit a crime. We're simply trying to create the appearance or raise enough doubt that it's confusing to a judge or jury and they don't know what to believe. And really that's the key, because if a judge or jury does not believe unanimously beyond a reasonable doubt that something did or did not happen, then they have to, by law, find our client not guilty. When clients maintain their innocence, which many of our clients, if not most of our clients do, again, it's a fact-by-fact analysis or case-by-case analysis on what do we do to try to further or perpetuate our client's defense. Sometimes that is us making a determination and a strategy where we do feel like it's important to go in and get our side of the story out to law enforcement. We want to participate in a recorded interview because we know down the road a prosecutor and then ultimately a judge or jury may be looking at a video and watching our client's body language or the sincerity of our client's emotions and how our clients answer those questions. It's one thing to be accused of a crime and then 2 years later be sitting in front of a judge or jury denying that something happened and knowing that in their minds they're trying to envision what could have or did take place at some previous point in time, as opposed to having a recording where we sat down and cooperated with law enforcement and gave a very clean cut explanation or a very believable version of events. Sometimes it's not to our client's benefit, because if they have to lie or deny any one fact that can be disproven by law enforcement, we're at risk of the entire house of cards falling apart on us. So being familiar with how these interviews take place, having years and years of experience in for both Ashley and I in working with law enforcement on how they interrogate individuals, how they question individuals, and adequately preparing our clients for how to answer those questions succinctly and clearly to help exonerate them is a huge benefit to our clients.